Alex here with part 50 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will quickly glaze over, however, are number one, I am not in the middle of this right now. My case is completely and totally over. It's closed, it cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. Another thing I like to mention every 5th video, and we're on video number 50, is that if you're one of the people who's wondering why you're not getting all of the updates on the My Docket series, it's probably because you have not clicked on the bell notification. If you are just subscribed to the channel, YouTube will only occasionally send you updates on the channel, but if you click on that bell notification, YouTube will send you every single update on the channel. This is not going to be much of a sort of discussion on my mindset at the time. A lot has been happening in the case, and my hopes were not very optimistic, but at the same time I wasn't totally on the one hand I was optimistic because I was making headway in both cases. In my child custody action, I had gotten joint physical custody quite some time ago, and in the case against the government, their efforts to sort of stall didn't work. The judge ordered that they had been served, even though they were arguing that they hadn't been served. I talked, a lot about the technical issues with some of this stuff in previous videos, and that's kind of what I meant by saying that in this video we're not going to have much to go over with regards to the mindset. As far as setbacks, I did have a pretty big setback in the child custody action in that during that last hearing video, which is part 49 of the My Docket series, the judge was very annoyed and irritated at the fact that I had been filing so many post-judgment motions. He didn't seem to care much about the contents of the motions. He just thought there was too many motions in too short of a time, and we were just annoying him, specifically me, because I was the one without an attorney. Anyway, all of that kind of doesn't really help to explain my, expectations when I finally ended up getting the response from the government in my action against the Secretary of State. And I think we, at this point, really just have to go into what the Secretary of State has filed. Here we have the government's respondent's answering brief, and I have not actually looked this over prior to going through this video, so you're going to get my reactions pretty much in real time. I cannot remember anything at all about this filing. I do know that this filing was instrumental in the dismissal of this case, but I've already really gone over those reasons, so the only benefit to this specific video is perhaps looking at the actual technical, points and authorities in support of dismissal of this case. But let's go ahead and just get down into it, take a look here. First paragraph, as with my previous videos on pleadings papers, this is just sort of a summary as to who is filing the document and who they are represented by. In this case, it's Secretary of State Ross Miller at the time. We have a new Secretary of State now. And the attorney for the Secretary of State is the Attorney General, Catherine Cortez Masto. Again, we have a new Attorney General. This was filed, I think, back in 2010. Let's take a look here. 2010. The answering brief is the formal response to my petition, and well, no, it's not. It's the formal response to my opening brief. There is a difference there. The answering brief is going to contain points and authorities, just like my opening brief should have. I don't think I did cite a little bit of law. It should have been more thorough, much more thorough. Anyway, the purpose of this document is to go over each and every assertion that I've made in the opening brief and controvert it. If it's not controverted, that's a problem. It could cause whoever's filing the answering brief to lose on that issue. The answering brief is also an opportunity for the government to raise new issues in support of their defense. And any of those new issues raised, I will have an opportunity to deal with when I file a reply brief, a reply to this answering brief. And that is coming up later in the series. Signature by Catherine Cortez Masto. Actually, no, it's by the Solicitor General who is now on this case. He was just put on the case. His name is Wayne Howle. Table of contents. This is consistent with what is articulated in the rules of appellate procedure. I don't think at first I thought that this was the case, but now as I'm looking at this table of contents, I am really thinking that given the fact these papers are named after the actual filings that occur in the Supreme Court of Nevada or Court of Appeals, it's likely that the statute, and I'm not going to go double check it because number one, I might be wrong, and number two, even if I am correct, the law could change later and it could just confuse my viewers. But my suspicion is that the statute that goes over petitions for judicial review actually has some kind of connection or link, probably referencing the rules of appellate procedure, and that's probably what's controlling the way that these documents are supposed to be filed in this case. But yes, the formal documents filed in an appeal, the opening brief, the answering brief, and the reply brief typically have these tables of contents, tables of authorities. It's just something that the rules require you to put into your brief. Here's the table of authorities that I was just talking about earlier. It contains the cases, the page numbers where these cases are cited, contains the statutes as well, and it contains the rules. Typically, they're broken down into these three parts. Here we have the Memorandum of Points and Authorities. I've talked about this in at least 2 videos. My first video that I would recommend is motions. The second one that I'd recommend is statutes, rules, and case law. This is broken down also into sections, and these are more strictly controlled. I talk about typically what's in a motion in the video motions. You're going to have a factual background, which goes over the facts of the case, and you're going to have a legal analysis or an argument, which goes over how those facts apply to the law and why you should get what you're asking for. This is going to be based specifically on the structure outlined in the rules of appellate procedure, and those rules do articulate that your brief should contain specifically a statement of issues, a case statement, and it goes over each of these elements or these items, and it goes over specifics as to what you should and shouldn't do in that particular area. For example, I think I'm not sure which one. I think the case statement or the statement of issues has specifics in there like don't go into too much detail. It should just be a brief list. For the issues. The case statement, it should just be a sort of quick rundown or summary as to what's going on in the case. Anyway, it's always important to check that kind of stuff so that you can get your brief as up to par as you possibly can get it, being a non-attorney. Or if you have an attorney, so you can review what they're doing, and I don't know, I guess you could say have confidence in what they put together for you. So first we have the issues here, whether the district court has jurisdiction to conduct a judicial review. The second issue is whether, even if judicial review of the decision is warranted, I have sufficient evidence to support the decision. Oh, no, not me. Whether the secretary had sufficient evidence to support the decision to issue the address. And the third one is whether my requested relief is available under the law. So those are the issues that they are putting out to the appellate court. The case statement here is going to have a summary. First paragraph talks about the fact that I brought a petition for judicial review under that specific statute. I have this just idea in my head that and I've talked about this a little bit before, but that I just went to the self-help center or I went to one of the websites and I found this petition for judicial review and just thought it just sounded right. I had probably had no idea, at least at the time, that a petition for judicial review is controlled entirely by NRS. Wait a minute, 217 probably isn't the chapter. Even if it's not, okay, so I don't think 217 is a chapter. There's another chapter, but the point is there is a specific, chapter that talks about what judicial review is, when it can happen, and all of the constraints. Now that I'm looking at this, I'm pretty sure 217 is the one that talks about the confidential address program. But it doesn't matter, because what I meant to explain is important, is a point, is a thing. It's something that is going to impact heavily the dismissal of this case. And I'm sure it's going to come up later on in this brief. Next paragraph, we have that I claim injury because of the Secretary's action. Because I am unable to locate my child and my son's mother. I don't really care where she is, but coincidentally, wherever my son is, she is. So it's not like I'm obsessed with her whereabouts. It's just the fact that that's, a right I have. I have a right to know where my child is. I claim the Secretary's action was improper because it was based on insufficient evidence, and that's because the statutes talk about the evidence that's required. It's not just like I come up with that phrase. Next paragraph here, I am requesting reversal of the Secretary's decision to issue a fictitious address in order that the Secretary reveal the location and costs. The Secretary contends, this is the next paragraph here, Secretary contends that my petition should be dismissed or denied. First, the respectful contention is that there is no jurisdiction for this court to review the Secretary's decision because the decision was not a result of a contested case and is not otherwise subject to judicial review. This is correct. This is the beginning and end of my case. I have failed to state a claim, and the petition should be dismissed under Rule 12b-5. Yes, he's correct. And I didn't find this out until I learned more about law, until I reviewed the decision from the Supreme Court, because this judge actually gets it wrong. He denies my petition for other reasons, but it doesn't matter because the Supreme Court reviews it, and they do state that he's wrong, but they state that it doesn't matter because the result that he reached was a correct one anyway, because I lack jurisdiction for precisely this reason here. The statutory scheme that controls when a petition for judicial review is available actually does specifically state in the law that it has to be a decision that is the result of a contested case. That is a key phrase. It's mandatory. There's no way around that. And since, let's actually read on here. I'm sure they describe it more clearly. So here's the argument. Judicial review is not available to examine a decision of the Secretary that was the result of a non-contested case, it's true. This is not an issue where I and my ex provided input to the Secretary of State. Let's just continue reading here before I go into a tangent. Not every decision made by the executive branch is subject to judicial review. That's true. And I didn't know at the time. It didn't sound fair. And I talk about the wrong-headed approach of seeing the court system as fair in the video, fairness versus the law. Coincidentally, it's fair in many areas because we, as citizens of this country, expect that. But not all areas of the law are fair. And again, the video that I recommend there is fairness versus the law. So not every decision is subject to judicial review. That's true. And this decision in particular is among those that are not subject to review. Because this decision is not subject to review, I failed to state a claim upon which relief can be granted. They're seeking summary dismissal. I actually have a video on this, and I think that video is called Motions to Dismiss. I'm like 99% sure. But it explains how you can sort of obviate the need of going to an evidentiary hearing or a trial by using that approach, and that's what the government is doing here. The government is saying, even if everything that I say is true, I can't get what I want because of some particular law that applies. And in this case, it's true. I am making a series of allegations that, even if true, do not entitle me to relief. Why is that? It's because this particular decision was not a contested decision. It's going to seem like a technicality to my viewers, and it is a technicality, but technicalities do control on issues like this when that particular technicality is a jurisdictional flaw, which this one is. To give the court, to give the judge the authority or the power to review this, he has to actually have, consistent with the law, a decision that was made by the government that was contested. And because he doesn't have that, he doesn't even have the power to sit and preside over this particular action that I brought before the court. Here's the Nevada Administrative Procedures Act. So here's the chapter I was talking about, 233B. So not the other one, but this one. This establishes the general provisions controlling judicial review. And the Secretary of State cites these two laws. No, they're citing a total range of laws. And they're stating that judicial review is provided for specifically at 233B.130, which is true, and that it's only available for decisions resulting from contested cases. Now, the government is not just citing the law, they're also citing a case. And this case here is Private Investigators Licensing Board v. Atherley. And in that case, the Supreme Court being they go over precisely what a contested case is or isn't. And what was challenged in that case was a license application procedure. And it's very similar to what my ex did. It's very similar to how the confidential address program works. She files an application, they review it, and they issue an address. I'm not involved in that decision-making process. It's not a case. It's not a hearing. It's not adversarial. It's just, you just walk in and you turn in an application. It's one-sided. And because of that, it's not contested. And because it's not contested, judicial review is not available to me. And this is the beginning and the end of my case. We are going to look at the other arguments that they brought up, but none of them really matter. They do trigger dismissal in this case, but as I mentioned earlier, the Supreme Court discards all of that anyway. And they just say, hey, you were right, but you didn't have to go all this way. You didn't have to go at all this length and analysis. You really could have just stopped on page, what is this, 2, 3? On page 4, paragraph 1, or even 2. And just right then and there, that's it, I'm done. So let's just go ahead and continue on, though, as I mentioned. They're going further into what a contested case is. They're stating, here's another, I guess this is another statute they're relying on. Contested case only exists when an agency hearing is required by law to afford all parties an opportunity to respond and present evidence and argument on all issues, which is true. And in this case, as I mentioned, the confidential address program doesn't involve any of this. There is no hearing. There is no opportunity for me to respond. There is no presentation of evidence in the sense of how courts operate. She does have to turn in a particular document, but there's no formal process. There's no, arguments as to who's right or wrong. It's just a one-sided, very simple process. Just as there was no contested case resulting in the recall petition, so they're drawing an analogy here. They're citing another case here where they were able to get a case thrown out that was brought up before the courts on judicial review. And drawing an analogy is an effective way to use case law to win your case, which is what they're doing here. Their argument is good. It's a good argument. There is no adversarial hearing established, and the Secretary has only 5 business days within which to review an application for fictitious address and make a decision. The legislature plainly did not intend there to be an opportunity to contest the applicant's bona fides, nor should there be. I don't know about that second, little, piece there that they added in there, but that's debatable. The first part of that sentence is true, though. The legislature did not intend for there to be an opportunity to contest the application. It's stated plainly in the law that they added. It's not very plain. Actually, it's kind of confusing because they have one section of law where they indicate that the program is for actual victims, but then they have another section of law that indicates that a certain there's like a list of 5 or 6 things that somebody can provide. If one of those is provided, it states that the secretary must issue the application. And one of those things that is in that list that forces the secretary to issue the license is actually a thing that can be given even though domestic violence hasn't been established. And that's something that I talk about in the video. I think it's domestic violence, actually. If not, it's part 2 or part 3 of the My Docket series. It's probably both. But anyway, the restraining order, the temporary restraining order, that's what I meant to say. The temporary restraining order can be issued if somebody is possibly a victim of domestic violence. There is no actual proof that's required to show that they are a victim of domestic violence. Somebody can show that to get one, but it's not required. They can just show that there's a chance that there might possibly be domestic violence. And for that reason, that's where this whole thing blows up and goes to the Supreme Court on the next thing that I file, where I do actually win my case. But we're not there yet. At this time, we are going through this petition for judicial review, which I am unfortunately destined to lose. In situations justifying a fictitious address, there's almost always going to be a querulous third party. The secretary could not mediate the disputes. It's true. I mean, I don't know. They probably could mediate the dispute, but there's no real point in really going into this because under the law, they're not required to do it. So, I mean, they can sort of get into the policy and the problems with dealing with these quarrels. They could do that, but it's not really required to win their case. They kind of just did that as an extra. Outside of the APA, judicial review exists only as otherwise expressly provided by statute. This is just more in support of their argument that judicial review is not available to me. Let's like administrative decisions. So they're just citing more and more case law. They're just piling it on. They don't really need all of this, additional case law. But it doesn't hurt their case to have it in there. The determination of the sufficiency of the evidence is ordinarily accorded deferential review. Factual findings are given deference and will be upheld if not clearly erroneous. However, in this case, the evidence relied upon was sufficient as a matter of law. This is what I was talking about earlier. The law states that an applicant for an address is required to provide specific evidence showing that, etc., etc., etc. And then they go into the second statute here, and this is the subsection 4, which actually provides a specific list, which, let's take a look here. They mention it right here at this line. A temporary restraining order is within that list, and that is what she provided. Now, I do want to mention that the restraining order that she provided was expired, and the Supreme Court of Nevada does eventually point that out. But, I mean, it doesn't really matter because the law doesn't state whether it should or shouldn't be expired. The law just states that they can just show a temporary restraining order, and just like that, they magically get one of these addresses. Anybody, it sounds to me like anybody can just pull one of these like a 12 or 13-year-old temporary restraining order and take it down to the confidential address program and get a fictitious address. If they really wanted one, it's that easy to get one. I don't even think they care if you're in any real danger at the moment. As long as you have that specific piece of evidence, they have no choice but to issue it. So here we have, so again, this argument, I mean, we could talk a little bit about it, but there's hardly any point because the case doesn't really get this far anyway. It's just a dead case because the court just doesn't have jurisdiction over it. But what they're saying is true. When an agency makes a finding of fact, the appellate court defers to that agency's findings of fact if that particular finding is supported by what they call substantial evidence. It's not what you think. Substantial evidence is, I'm just going to direct my viewers to a video. I talk about what it is and how it works in the video standard of review, but it's definitely not what you think. You should take a look at that video. And yes, this is true too. Remedies which I am seeking are not available. I'm requesting several forms of relief, including reversal of the Secretary's grant of a fictitious address, disclosure of a whereabouts and costs. These are not only unwarranted but unavailable. That's not true. Let's take a look here. Well, definitely they can disclose the whereabouts because they ultimately lose the other lawsuit that I file and are ordered to disclose the whereabouts. Also, the Supreme Court of Nevada says that they can, and under certain circumstances are mandated to. Cost, as far as I know, if this is a special proceeding, then for sure I'm entitled to costs. If it fits into some other category, then I might not be. Even if there were, the remedies are limited by statute. The court can remand or affirm the final decision or set it aside in whole or in part. NRS, the law, okay, what are they citing here? But only if the decision of the agency is A, B, C, D, or E. They go over a list of criteria here. I would say subsection B might apply. As already described, none of these conditions exist. I don't know, that's arguable. But there's no point in talking about it because, as I mentioned, the case doesn't get this far anyway. There's no provision in the APA or anywhere else authorizing disclosure of her residential address. Yeah, that's true. There is no provision in the APA, but there is a provision in the specific area that discusses how the confidential address program works. So that's ultimately what the Supreme Court of Nevada cites when I actually win this case. But right now, I suppose to have more arguments in their favor, they're trying to sort of act like they're constrained by the APA when there's another remedy available under another section of law, which doesn't, ultimately control. Relying on 18.005, which only defines costs. It does not authorize their award. There is, in fact, no authority for him to claim costs or attorney fees in a judicial review action. Okay, that's, well, as I mentioned earlier, if this is a special proceeding, then yes, I am entitled to costs. And I know this because I won an appeal on this issue. But if they're right and it's some other type of proceeding that doesn't fit into that category, then I probably am not entitled to costs. I'm not going to look into it any further because I'm not going to end up winning this case anyway. Conclusion, that my petition for judicial review should be not even be entertained by the court because there was no contested case, and therefore I cannot state a claim. And even if it is given judicial review, then it's supported by adequate evidence as a matter of law. And that's actually is true in a really weird way. It's not that they're considering evidence like they're weighing it. It's that they're saying that this particular piece of evidence fits into this category listed in the law, and so they can't even really weigh it if they wanted to. And that is what the Supreme Court does ultimately say when I bring this issue back to the Supreme Court later on. They do ultimately say that under the law, the Secretary has no choice. They can't sort of use their discretion or their thinking or their... what I'm trying to say is they're forced by the law, once given something within that list, to issue the address, and they have no choice about it. Affirmation here, this is, as I've mentioned in many of my previous videos, a document that just indicates this particular filing does not contain a social security number. The clerks will make sure that the document contains this affirmation, and they will take it at its word. Some of them will skim through and check just, if a social security number jumps out at them, but many of them don't even bother to do that. Next page here, certificate of service, and this document, or this particular certificate, just is indicating that this document was served upon me, and more specifically that it was served upon me by mailing it, which they can do under Rule 5, which I've already talked about on a number of occasions. If anyone is wondering how that works, I think I have a video on this topic. I think I talk about it most in a video titled Notice of Change of Address, actually. You wouldn't think that, but well, those two things are kind of connected, because stuff gets mailed to your address, and if you've moved, it'll get sent to your old address, and it'll still count as being served on you. Index of exhibits here. Exhibit 1 and 2. I think I was actually excited when I got these because, well, actually, we're not going to go over Exhibit 2 because I've already covered that. I think it was in video... I think it was part 9 of the My Docket series, if I remember correctly. It might be wrong. No, I'm pretty sure it was part 9. So as with my previous videos, anytime we go over a document that I've already covered, I will skip it, but I will mention to my viewers where they can probably find it. And I will also go ahead and mention right now that I keep links to these documents down in the description below, so you can always click on that description link. Download it for yourself, and if you see something that you want to talk about, just post it down in the comments. We will cover Exhibit 1 because I haven't seen this yet. A lot of it's redacted, so I'm not too concerned here. It's just her name, all the stuff that's already been in many of my previous videos. The whole thing is redacted pretty thoroughly. And then, it's just indicating here that she, oh wow, lovely. Which of the above are known to your abuser? Mailing and work. And then, of course, do you want to vote? And then they've got a section here where they are stating that they are a victim of DV, stalking. She fears for her safety or the safety of the applicant so I guess you could do it on behalf of a child. They understand that knowingly providing false or incorrect information on this application is a misdemeanor, that's it, and may cause my participation in the program to be canceled. I doubt that I could have got her on any kind of lie here because she doesn't really lie. She just attaches that temporary restraining order. Her attorney probably told her to do it. Anyway, she doesn't really have to lie. She's just saying, hey, here's my restraining order. And that's it. Well, I guess you could argue that she's lying about being in fear of her safety. Yeah, but I mean, how could somebody prove something? I mean, how could you controvert that? That's just subjective. Whether or not somebody is in fear, that's in their own head. So, I mean, a person could conceivably unreasonably be in fear of you, and you can't do anything about it because while it's unreasonable, I mean, they still in their brain feel fear, or at least that's what they're saying. Authorization letter, probably issued by the government. Nothing really jumps out at me as important. Confidential, another authorization letter. Oh, she must have got it for him too. Lovely. The reason I'm very cynical about this, and my viewers are going to find this out later, but there are times when people, I don't even know who they are, I think it's teachers, are filing CPS reports on her, and they can't find her, so they close the case. So she ends up using this confidential address for so-called victims of domestic violence to actually conceal what later amounts to actual physical harm that she's been inflicting on him. You're going to see this come out in the series after I get joint physical custody. I do end up finding out through a psychologist, and I've mentioned this before, that she was physically abusing him. And by this point, she had already lost so many of her parental rights that there was very little she could have done to him anyway at that point. But I find out that that's going on, and I just kind of look back and I think, wow, She used the confidential address program to hide from CPS even. And they closed the case because they just didn't even want to bother trying to challenge it. They're just like, well, we don't know where she is. We have a fake address. And anyway, it's really frustrating for somebody to lie to obtain a fictitious address when they don't need to hide from you. But it is just absolutely infuriating to have somebody who not only doesn't need it, but they use it as a weapon against the other government agencies that need to protect the child. So it's like, I've talked about this before in the video, exploiting good faith. Everything is turned into, they see everything and turn into a weapon. They find some way to take something that was meant for good and weaponize it. And that just, watch that video if you want to go, a little bit deeper into what I'm talking about. But I have many examples where she exploits good faith, takes something that's good and just turns it around and use it against you or the government or whoever. A confidential address program declaration. Looks like it's just the employee. They interviewed her, and that's in their professional opinion that she is that she has been a victim. Okay, so not even close. What probably happened is she was just given the piece of paper and she just believed it. Like this person, Sylvia Gonzalez, way off. But I mean, that's how things are when it's just one-sided. You don't have the other side that's able to, bring up, contradictions, expose contradictions in their statements and stuff. So when it's just a one-sided thing, it's easy to be convinced when there's nobody else saying anything on the other side. Temporary restraining orders, marked box here. Referred by the judge, she says. Well, she does have that order, so. I wonder if this employee, Sylvia, let's go back here for a second. Wherever her name was, I wonder if she had any clue that this was going to be the case that kicked a hole the size of a truck through that program. Yeah. Confidential address program checklist for application. She just kind of initials everything here. Reviewed the statutes. She's applying under a name other than her legal name, which could result in the denial of privileges. She's been informed that she is responsible to initiate all requests for the use of the address. She's discussed the impacts of giving personal information to government agencies and private businesses. Let's see here. She has discussed the limitations of the participation in the program when dealing with private companies and initiating services requiring a site address. Probably like they're explaining how you can't really send like a cable company to your fictitious address because you actually need to get, cable installed at your house. Probably stuff like that. She's understanding that there's a potential for law enforcement to gain access to the records held. She also understands that the information could be released upon a court order, which it does, this actually does ultimately happen. They probably told her, don't worry, this never happens, and this would be the case where it actually does happen. She, let's take a look here, is informed of the termination procedures. She understands that the provisions in the law apply to all participants, and she understands that not complying with the law may result in termination. She also understands that falsifying information on the application or becoming a participant in a criminal subterfuge may result in the release of the information on the application. And stuff about mailing or voting, and a little bit lower here. The authorization letter and card that she will receive is important, and she may not expect the use of CAP privileges unless she can produce either the form or the letter. Mail sent to the fictitious address can be returned to sender if sent under any other name or address without her authorization code. Oh. Curious. So there's some kind of code that has to be included in the address, apparently. Weird. I didn't know that. The participation can result in her commercial credit history, timely receipt of mail, service of process, and emergency medical response. Oh, probably because stuff will get sent to the wrong address. And she understands that it's her responsibility to decide when and where to use the participation, and that she can choose not to use the fictitious. She can choose not to use it, or not to request the name and address confidentiality. Oh, I see what she's saying. So I guess you can also request confidential name, like a confidential name on the address. We got the employee from the representative stating that she helped the applicant complete the application and that she provided initial orientation to the program. And here's Exhibit 2, which we've already gone through. Going into the aftermath, I didn't file this document, so I incurred $0 in costs. The government filed this document, but it was one of those free filings, so they incurred $0 in costs as well. I didn't have an attorney, so I incurred $0 in attorney fees. The government's lawyer probably spent somewhere between 1 and 2 hours on this. The reason it's such a low number is I imagine that they kind of have this case law just lying around. I'm sure there are a lot of self-represented parties who use petitions for judicial review in the wrong manner, like I did, and so they probably just pasted a bunch of that stuff in there. Maybe did a little bit of research to make sure the law was still current, but for the most part, I don't imagine they had to put a whole lot of time into filing this answering brief. So 90 minutes at the rate of $250 an hour is going to come to $375. As with my previous videos, if you have any questions, feel free to post something down in the comments below, and I will see you guys next time.